Pat Iyer here, host of Legal Nurse Podcast. In this upcoming series of podcasts, I'll be sharing with you some specific shows about working on forensic cases. Legal nurse consultants can serve criminal defense attorneys and criminal prosecutors in a variety of ways, and our programming is designed to bring some of those concepts to you. Be sure to check out the conference that is coming up May 30, 31, and June 1st, 2024, called Murder Mysteries Unraveled. This is a 3-day conference highlighting a variety of topics to give you the skills that you need to effectively consult on criminal cases. You'll meet a variety of experts and participate in activities that will open up your eyes to the opportunities that exist to get your foot in the door in this field or to get more cases from attorneys who are handling criminal cases. Look for that link at the end of the video and also right below here, which is lnc.tips/murder. Now for the show. Welcome to Legal Nurse Podcast. I am Pat Iyer, the host of your show. This podcast is heard worldwide, and we love the idea of being able to share tips, knowledge, support with you in your legal nurse consulting career. Today, we're going to focus on the role of the nurse working on a criminal case in helping to look at the evidence, applying our knowledge as healthcare providers in this specialized field where the stakes are incredibly high. I'd like you to meet Teresa Devitt-Lynch, who is a forensic nurse, a sexual assault nurse examiner. She's board certified in forensic nursing and is an educator, an expert who testifies both internationally and nationally. Teresa, welcome to the show.
Hi, Pat. Thanks.
One of the first things that you have to think about when an attorney contacts you to review a case is, what is the evidence? And tell us, what is your thought process when you think about the evidence and the questions that the attorney is asking of you?
So one of the things that I always ask them, now most of my cases come from defense attorneys, and it's not because that's who I market to, that's just who calls me. I am open, and I do work with prosecutors from time to time, but the majority of my work is with defense attorneys. So I'll kind of be talking from that standpoint. But in talking with them, it's very important to find out what they want from you. Is it something that they want you to consult on only or to testify on as well? To make sure that you have the expertise in the area that they may need testimony. Another thing is if they're willing to share with you what is their theory of the case, especially if it is a homicide case. Are they, claiming self-defense or that it was an accident? If it was an assault case, are they claiming accident? If it was a sexual assault, are they claiming that it was consensual? And that helps to get an idea of where they're taking their case, and also a little bit of information about the case.
And do you have access at all to the charges at the beginning of your work on a case?
No, I don't get that until after I've been retained by the attorney. So once we've decided that I'm a good fit for them and I can assist them with their case, then they'll retain me, and then they'll send me the discovery. So the discovery is all of the evidence, basically, in document form. So it includes any pertinent medical records, sometimes not all of them, the police interviews, the police recorders, the chest recorders that they use now, any witness interviews, any, the list of forensic evidence that was collected at the scene, photographs of the scene, and any photographs of the victim, living or dead. If there was an autopsy, then that would be included as well. So then once I get the discovery, one of the very first things that I do is I look at the indictment, and the indictment is the list of charges that the assailant is being charged for. And there's a few reasons for this. So the indictment and the charges, it's the roadmap for the prosecutor. So these are the elements that the prosecutor has to prove to the jury in order for them to be able to find the defendant guilty. And so on the flip side of that, these are the charges that the defense attorney is either trying to lessen or mitigate. So if he's being charged with first-degree murder, maybe they're trying to get it knocked down to manslaughter and say it was an accident or it wasn't intentional. If it's a first-degree assault, maybe they're trying to get it knocked down to a third degree. So, or they're trying to refute them completely and say, this did not happen, or they have the wrong guy. And then another reason is the charges or the indictment, they usually refer to or are sometimes mention the types of medical elements that I'll be looking for. So significant bodily injury, strangulation, things like that. Because then again, those are the elements that the prosecution is trying to prove. And then finally, the indictment might also include elements of the motivation of the crime. So was it intentional? Did they determine it to be reckless, or was it negligent?
Can you pull those apart for us and tell us the difference between them?
Yes. So the lawyers, obviously, I'm going to give you a quick rundown. I am not an attorney, but just very quickly, and there are different levels of intent. There's different levels of recklessness. There's different levels of negligence. But those are the three basic elements when it comes to intent, or the mens rea, which is the Latin term for guilty mind. So in order to be proven guilty of intentionally inflicting injury on somebody, the prosecution has to show that the defendant had the intent, or they willfully and purposely acted in a manner to harm or kill somebody. And then there's also recklessness. Now, recklessness is kind of the less, or the next step down from intent or intentional. This is when a person should have known or did know their actions could cause harm. So recklessly driving while under the influence. We all know that when you're driving under the influence of a substance, alcohol, drugs, whatever, that your reaction time is impaired, your decision-making is impaired, your vision could be impaired. So knowing that, getting drunk and getting into a car, you may not have had the intent to purposely harm somebody, but you should have known not to get into that car. And that would be recklessness. And then finally, there's negligence, which is a lack of intent, but involves the failure to exercise reasonable care. So not taking precautions that a reasonable person would have done under the same circumstances. So I guess, I was just going to give a quick, you go ahead.
We had a situation, Teresa, that almost turned into one of these charges last week when we were on vacation. My husband and I were in the car, and there were two bikers in this narrow driveway that led out onto the street who were blocking our path, who were consulting a map and deciding where they were going to go. And my husband patiently waited for them to move out of the way, and they belatedly turned around and saw our car, or heard our car, and moved to the side. But in that second, while he was focusing on them, two people on bicycles rode from behind a wall that blocked the vision right in front of the driveway. And he was advancing the car slowly to get out on the street and almost hit that woman.
Oh my goodness.
I glanced back at her after we got on the street, and she was turning around and glaring at him for all she was worth. And I said to my husband, that was really close. When I saw them coming, I said something or used some word like watch out, which stopped him, and he hit the brake pedal. So I'm thinking, as I'm listening to those charges, that would have been no intent. That would have been a negligent operation of the car if we had hit her on the bike.
Quite possibly, yeah. If it would have turned into a criminal matter.
Let's talk about the evidence that the prosecutor needs to utilize to establish that intent. I read all the time about cases that are built on circumstantial evidence, but doesn't lack the strength that's needed to result in a conviction, or raises the question that somebody else did it.
Right. So in circumstantial evidence, as opposed to direct evidence directly links somebody to the key issue at fact or the crime. So if you have somebody's fingerprints on a knife that was used to stab somebody, that would be direct evidence. But the majority of the evidence that is shown in court and used to prove criminal charges are what is called circumstantial evidence, and that's where medical evidence falls into utilization. And this evidence doesn't directly show the key elements of the fact or the key fact at issue, but if taken at face value and if believed, the juries are able to utilize circumstantial evidence and reasonably link the suspect to the crime. And so you do hear a lot of the times it's a circumstantial case, but it's a strong case. And that usually means they may not have a lot of, if any, direct evidence, but they've got a lot of strong circumstantial evidence that when collected and compiled and reviewed in totality by the jury will lead them to find the person guilty.
And then there's always the little elements of, does the prosecutor tell the defense attorney when they have found evidence that would get that victim, that defendant off the hook, but because they really want that conviction and it's such a strong need, they hide or overlook or deliberately not share that information. That was just the plot in the book that I finished 2 nights ago.
I was going to say, so that would, in the United States, that's what's called a Brady violation. They're required to turn that over. But right. I mean, I watch all the reality, documentary series, and there's, you hear of cases every now and then where maybe something got overlooked or maybe somebody, didn't turn it over for whatever reason. So it can happen. It can happen.
Yes. This woman ended up being forced to resign her position as prosecutor and ended what she thought was a promising career.
Yeah, that's unfortunate.
When we look at medical evidence, and this is where we have such strength in terms of being able to help attorneys understand these, what aspects of that case can medical evidence be used to help establish or prove or disprove?
So in addition to some extent, the medical evidence can be utilized to help establish or prove mens rea or the guilty mind. But there's also the Latin term actus reus, which is the term for guilty act. And so these are the physical elements of the crime. What happened during the crime? What did that criminal do? What actions did they take to commit this crime? So in order to get a conviction, not only does the appropriate mens rea need to be proven, but also does the actus rea. And this is where, again, the states, they would hope for direct evidence, but a lot of the time they have mostly circumstantial evidence. But this is an area where medical evidence can be utilized to more strongly reconstruct a crime, that it can to help determine intent. But there are some cases in which the medical evidence could be utilized to determine intent in, say, a homicide, or to also help in determining if it was a self-defense or if it was an accident, different elements of the crime there.
I know that when I read my murder novels, which I read quite frequently, they talk about the motive, the means, and the method. I don't know if I have that quite right.
Motive, means, and opportunity.
Motive, means, and opportunity. All right. So all of those, are they used to establish intent, or are they used to establish something else? What are those three motivations for murder?
In talking with different detectives and working with a lot of lawyers throughout the years, there's three basic motives for murder, and that is love, money, or vengeance. Usually most of the cases boil down to those. And although medical evidence may not be able to fully determine, intent in murder cases, that can be very useful in some non-fatal incidents to just support different levels of intent. For instance, I actually had a case several years ago in which the defendant was being accused of strangling his wife, and she had some external injuries consistent with strangulation, and she reported, breathing problems and coughing, and had a sore throat, and other, signs and symptoms that supported the strangulation. And his stance was that they were in a heated argument, and he was just trying to keep her from swinging at him because she was being the aggressor. Now, in this situation, there were bruises on her neck that were consistent with, his right or left hand being around her neck. And so if somebody is trying to get someone to not hit them or punch them, they certainly wouldn't need to apply pressure around the neck with enough force and length to cause bruising on the neck. So that element, that piece of medical injury or medical evidence injury, could certainly have been used. The case did settle out of court. He took a plea deal, but certainly that could have been utilized to show his intent to harm her versus protect himself. That is one way in which medical evidence can be utilized to help establish intent.
And in our conference coming up, we're going to have a full session on strangulation, what marks are left on the neck, what legal nurse consultants should consider when looking at photographs, and how that plays out in a murder case.
Yes, we do. We have Tristan Riston who will be providing that presentation, and I've listened to her speak multiple times, and she's a fabulous presenter with a good breadth of knowledge in that area.
You mentioned actus reus. Actus reus. I have to pronounce that correctly. How does that relate to what we're talking about with medical evidence?
So along with the other evidence, the presentation of the scene, was there a sign of a struggle? What trace evidence, what body fluids, what other pieces of evidence were found at the scene? How the medical evidence can be utilized in conjunction with that information and evidence to help to reconstruct the scene. So if you have, maybe a pattern injury could be associated with a specific weapon. You might find a boot mark on someone's back that could be used to match up with a specific shoe that was worn to help reconstruct that. When you're talking about gunshot wounds, you can determine through the presentation of the entrance and the exit wound, and whether there is soot, gunshot residue or stippling, the approximate distance of firing. So that can be used to help determine how far away the victim and assailant were. Also, the angle of wounds, what was the angle of a stabbing? What's the entrance angle and exit of a gunshot wound? Those can help to determine where people were standing during, whatever altercation may have happened. And then just the injuries alone can help to determine the mechanism of injury that was utilized. Sometimes you can associate it with a specific wound, or I'm sorry, with a specific weapon. The type and the length of a knife may be utilized. You could, for instance, determine, was it a serrated knife versus a single-edged knife versus a double-edged knife, based on the presentation or based on the pattern that it makes as it's being thrust into the body. So there's a lot of ways in which the medical evidence can certainly help reconstruct and to determine the actus reus of the case.
And I know another factor in terms of helping to rule out suspects are those things that you've mentioned. Is the person right-handed versus left-handed? How tall is the person who's being accused of the murder? Could they conceivably have created that injury based on, say, striking somebody on the back of the head? Can you tell us a little bit more about ruling out suspects with medical evidence?
Absolutely. So very rarely, except in the case of suicide, does medical evidence determine who did it. There's no, you don't have a bruise or a bullet wound with a label on it that says John shot me. That just doesn't happen. You can determine that they were shot. You can determine what type of gun was used. You can't, by the medical evidence, determine who shot the bullet or who shot the gun, who pulled the trigger. But you might be able to determine who could not have pulled the trigger. And actually, I had a case like this a few years ago. There was a gentleman who was paraplegic, and he had gross motor function of his hands, but he did not have fine motor function of his fingers. And he was in an electric wheelchair. So he had a way to get him to get around, but it was electric. He didn't have to push any buttons. It was just one of those big knob things that moved him around. So he only needed gross motor skills to do that. He did not have fine motor skills. He could not have picked up, and he was being accused of shooting somebody. I think I forgot to mention that. He was being accused of shooting somebody, and apparently they had an issue between the two of them. And so in reviewing his medical records, in reviewing photos of him, and I even talked to him on the phone to get more information about his daily capabilities. And in doing so, there was no way that this gentleman could have picked up a gun effectively. Now, mind you, he's in a wheelchair, and he was shot in the chest. So they were looking at each other. There is no way that this gentleman could have picked up a gun, much less pulled the trigger, in a time short enough for the other gentleman to not have noticed what was going on and gotten out of the way. But the prosecutors saw a picture of this man holding, I think, money or cards fanned out in his fingers. Well, his friends had put that there for him just for the photograph, and that was his basis. Now, the charges were dropped, but certainly the medical evidence, especially as it relates to the suspects, can be utilized to help rule them out. If you have a woman who's very arthritic, would she be able to hold a knife strong enough and to be able to thrust it into somebody strong enough to cause them significant bodily harm or death? And in this case, there was a paraplegic who was being charged with shootings, with attempted murder. The gentleman did live. It was attempted murder, but there was no way that he could have done that. So yes, so while it doesn't necessarily tell you who did it, it can, in some circumstances, tell you who could not have done it or who didn't do it.
Mm-hmm. And then there's all that DNA that's sitting on shelves waiting to be processed for years, backed up in our system, which is an unfortunate aspect of the delays in the criminal justice system.
Yeah, it's all about resource allocation and having enough people to do the job. And unfortunately, there's some areas that don't have, the rural areas don't have as many resources as some of the more urban areas do. And so it's kind of sometimes it can be difficult to keep up.
Mm-hmm. I know, Teresa, that people who've listened to this podcast or watched it on our YouTube channel, which is Legal Nurse Business, are going to want to know how to reach you. What would be the best way for them to do that?
Sure, I can be reached at my website, www.intrepidfhc.com. So that's www.intrepidfhc.com. So that's for Intrepid Forensic Healthcare Consulting. And then via email, I'm always happy to answer emails and to help people out. So I can be reached at Devitt-Lynch at intrepidfhc.com. So that's TDEVITTLYNCH at INTREPIDFHC.com.
Thank you. I appreciate your wisdom, your experience. I know that you could have talked for many more hours on this topic.
Yes, I could go on and on and on.
Thank you for spending the time with us, Teresa. And please, for you who's watching this, hang on. We've got another quick preview of who's coming up next. You'll have an opportunity to see what we're covering on Legal Nurse Podcast in our next episode. See you then. Coming up next on Legal Nurse Podcast, I'll be sharing with you a mesmerizing tale of a nurse who practiced nursing for 16 years in New Jersey and Pennsylvania. His name is Charles Cullen, and he is the subject of the book and movie called The Good Nurse. He is considered to be the most prolific healthcare serial killer, killing approximately 400 to 1,000 or more people in his career as a nurse. I'll share with you how I got involved in this case as a legal nurse consultant when I was hired by one of the prosecutors to determine which people Charles Cullen killed in one hospital. You'll hear the story, which is both an audio and a video program. I recommend that you go to our YouTube channel, Legal Nurse Business, and watch this as a video program, but it certainly has great value as an audio program as well. Coming up next, tracing the path of the killer who was a nurse, Charles Cullen. I hope you got some great tips from this program. Be sure to check out our 3-day conference coming up May 30, 31, and June 1st on murder. If you see this podcast after those dates, you can go to the link below the video, lnc.tips/murder, and get the recordings for the conference. Use those to build your knowledge about forensic cases. And I'll see you on the next show.